Hello, my name is Frank Ally. I'm a California licensed attorney practicing exclusively in family law. Now let's get started. In a prior video, we talked about the difference between temporary spousal support and permanent or long-term spousal support. In determining long-term spousal support, the courts are prohibited from using math formulas, and courts have been directed to use the statutory language of Family Code Section 4320. I've got a link here on the video to go to 4320. I would encourage you to look at it. 4320 contains 14 factors, and what the court is supposed to do is to look at the facts related to each of these sections. The court is then supposed to weigh these facts, balance these facts, and come up with an equitable solution when one party needs support from the other party going forward, and that's called the long-term spousal support. We're going to look at some of these factors individually. This particular episode is going to discuss the marital standard of living and how that relates to Family Code Section 4320. So I want you to see the board here, Family Code Section 4320. In ordering spousal support under this part, the court shall consider all of the following. And the first thing it says under Section A is the extent to which the earning capacity of each party is sufficient to maintain the standard of living established during the marriage, taking into account all the following factors. Before we get to all the other factors, I think we need to focus on the marital standard of living and figure out what that means, because it's almost like the gate you have to go through to analyze a lot of these other factors. So what is the marital standard of living? The marital standard of living describes the standard of living that the parties established during the marriage. It's a general description of the lifestyle the parties achieved prior to their separation. The characteristics may include income, expenses, lifestyles. Lifestyles means vacations, homes, cars, hobbies, and generally how they lived their life financially and how they arranged their finances during the marital status period. To show the marital standard of living, parties may introduce evidence about photographs of cars, trucks, boats, horses, watercrafts, or similar items. You can go through that whole narrative and establish through evidence, through photographs, through documents, through testimony, this is how we lived our life and this is how I define the marital standard of living. Because if the court's going to try to allow both parties to pursue a lifestyle in accordance with the marital standard of living, they have to understand what that marital standard of living is. The marital standard of living is to be weighed under the circumstances of the case along with all other applicable factors that the court's going to look at. They're looking for a fair and reasonable result on the issue of spousal support, and the marital standard of living is intended by the legislature to mean the general station in life enjoyed by the parents during the marriage. You can see that in the remarriage of Smith, 1990 case 225, Calap 3D 469 475. The link is here. And although a court may consider both the income and expenses in terms of marital standard, it may also base the marital standard of living on the family's average income rather than expenses. I find it, as a practicing attorney, a lot easier to try to establish a marital standard of living by looking at the income enjoyed by the parties during the marriage, with exceptions, which we'll talk about in a second. But to me, it's easier for me to go grab tax returns and look at income of what a party did to determine what the marital standard of living is, because that's easier to show, quicker to show using tax returns and W-2s and W-9s than it would be to try to go through and create a narrative about, well, we did a boat and we did it every other weekend and we did this car and we went to, Venice once a year type stuff. I mean, certainly you're going to use both sides of the equation, but I tend to rely on the numbers because the numbers are easier and quicker for the courts to understand and make a decision. The marriage of Sheraton, which is 92 Cal App 4th 269, page 307, the court said the court properly considered both expenses and income in determining the marital standard of income in this case. So In Sheridan, what the court did is they looked at both the income of the party and the expenses of the party to determine what that marital standard of living was. The whole key is the award based on the marital standard of living. It should be that the award should be sufficient that each party should maintain the marital standard of living. You can see that in a marriage of Weinstein, 1991 case, 4 Cal App 4th, 555, 566. In the Weinstein case, the court was presented with two measures of the marital standard of living by the attorneys. One was the actual expenditures during 6 representative months from the last year of the marriage, and an average income of over the last 6 years of the marriage. Given the evidence at the time the parties lived beyond their means, the court's decision to base the award was on the average income rather than the expenses. Contrary to suggestions by the party who wanted more support, the court says we're not required to maintain an overextended lifestyle based heavily on expenses or borrowing. Understand that the marital standard of living is not the sole factor in determining what long-term spousal support is. We're going to look at those factors individually. But it is a good starting point for any discussion or any exploration of the other factors in 4320. So what I would do is encourage you and your attorney to go ahead and make sure you have the tax returns for the last few years of the marriage, and make sure you're ready to present to the court to say this is what we earned during that period. And then have supplemental information in terms of documentary evidence, photographs, etc., on the trips, the cars, the houses, and other things that you did. You can also include, when you use the income analysis to determine the marital standard of living. In one case, the marriage of Drapeau, 2001, 93 Cal App 1086, made an interesting ruling about the term marital standard of living. It said the family in question spent very frugally and actually lived considerably below their means while investing a significant portion of the income. The court ruled that savings and investments were a valid category of expenses to be considered as part of the marital standard of living. So if you're tight and you're not spending all your money because you're investing for retirement or future things, the court's going to look at that and say part of this couple's marital standard of living is savings and investment for the future. That's one of the parts of marital standard of living, which is one part of the other 14 factors involved. In the marriage of Smith, though, the court went the opposite direction. The couple went to lavish parties, lived beyond their means, and that's where the court said this couple has lived beyond their means because they financed this lavish lifestyle with credit and charges, and that's where they said the expenses are not going to be worked, and that's Smith, 1990, 225 Cal App 3D 469. The one thing to remember is the courts have a very difficult time here, because what they want to do, particularly on long-term marriages, is they want to try to equalize the parties' ability to live at the marital standard of living. And one thing you have to understand is that when you have a specific amount of income or revenues coming in, and now you have to take that same amount of revenues or income coming in and support 2 households rather than 1. It means that when you get a divorce, you're not both going to be able to meet that marital standard of living. Both parties should equally have to sacrifice so that they continue living to the extent that they can, or the court can craft a solution to allow both of them to live in a similar fashion going forward. I'm Frank Ally. I'm your ally in family law. This is a difficult subject. It's not black and white necessarily. There's a lot of give and take on this, but it does provide some really good guideline for a starting point. Future videos will be following to discuss the other 13 factors in support, but this is kind of a biggie to start with. This is your gate. I'm Frank Ally. I'm your ally in family law. Oh, by the way, if you like this video, like it, subscribe, share it, and of course, tell all your friends. Thank you so much.